Question 1. Topic: Priority rules and conflicting interests during a major transformation where existing methods of financing are being replaced with more sophisticated credit structures. A secured lender, Lender A, properly files a UC1 financing statement on January 1, securing an interest in a company's inventory. However, on February 1, Lender B extends credit to the same company and also takes security interest inventory but fails to file financing statement. On March 1, Lender C extends loan to the company, obtains purchase money security interest (PSI) in newly acquired inventory, and properly files financing statement on the same day. The company defaults on all obligations. Which lender has priority in the inventory? A. Lender A, because it was the first to file financing statement. B. Lender B, because it extended credit before Lender C. C. Lender C, because properly perfected EI in inventory takes priority over prior perfected interests. D. All three lenders have equal priority and must share the proceeds. Answer: C. Lender C, because a properly perfected ESI in inventory takes priority over prior perfected interests. Explanation: This question tests the priority rules in secured transactions, particularly purchase money security interest (PMSIS) under UC Article 9. Lender A filed first, giving it a general priority under the first to file or perfect rule, UC SS 9 322A1. Lender B failed to file, meaning security interest is not perfected and is subordinate to perfected interests. Lender C obtained PI in new inventory and properly filed on the same day. Under UC SS 9 324B, properly perfected ESI in inventory has superpriority over prior perfected security interests as long as the PAI lender files before or at the time the debtor takes possession of the new inventory and gives proper notice to prior secured parties. Thus, Lender C has priority, and lender prior interest is subordinate to the PAI. Lender B's interest is unperfected, making it the lowest priority. Lender D does not exist, reinforcing the importance of careful reading in legal exams. Question 2. Topic: Default and remedies. While analyzing the root causes of sequential problems in enforcement actions, a bank has a security interest in a debtor's business equipment. The debtor defaults and the bank decides to repossess the equipment under the UC self-help repossession rules. However, the debtor refuses to allow access to the premises where the equipment is stored. The bank is considering its options. Which of the following actions is legally permissible? A. The bank may break into the debtor's premises at night to retrieve the collateral as long as it does not physically harm the debtor. B. The bank may file for court order requiring the debtor to surrender possession of the equipment. C. The bank may send law enforcement officers to seize the equipment without court order. D. The bank automatically loses its security interest due to the debtor's refusal to comply. Answer: B. The bank may file for a court order requiring the debtor to surrender possession of the equipment. Explanation: This question assesses self-help repossession under UC Article 9 and its limitations. UC SS 9 609A 1 allows secured party to take possession of collateral upon default. UC SS 9 609B 2 permits self-help repossession only if it can be done without breach of the peace. A. Breaking into the debtor's premises at night violates the breach of the peace, the doctrine, and is illegal. Courts have consistently ruled that any forced entry is breach. B. Filing for court order is the correct action. When self-help is not possible, secured party can seek judicial repossession through replevin action. C. Law enforcement cannot seize property without court order unless assisting under lawful judicial directive. D. Secured party does not automatically lose its interest due to non-compliance, or rather, it must pursue legal remedies. This question highlights the limits of self-help repossession and emphasizes the importance of respecting debtor rights while enforcing security interests. Question 3. Topic: Filing, recording in compliance with UC Article 9 in a situation where formal requirements conflict with practical enforcement. A lender files a UC1 financing statement against a debtor's general intangibles in the wrong state due to an administrative error. 6 months later, another lender perfects security interest in the same general intangibles by filing in the correct state. The debtor defaults on both loans. Most likely legal outcome: A. The first lender retains priority because it filed first even though it was in the wrong jurisdiction. B. The second lender has priority because it properly perfected its security interest under UC Article 9. C. Neither lender has priority, and the debtor's assets will be distributed equally among creditors. D. The first lender may correct the filing retroactively and reclaim priority. Answer: B. The second lender has priority because it properly perfected its security interest under UC Article 9. Explanation. This question examines UC filing requirements and jurisdictional rules for security interests. UC SS 9 3011 states that the law governing perfection is determined by the debtor's location. A filing in the wrong state is ineffective even if done first. Financing statement must be filed in the correct jurisdiction to be valid. B. The second lender who filed correctly has valid and perfected security interest, making it superior. C. Priority disputes are resolved based on the UC, not by automatic equal distribution. D. The first lender cannot retroactively correct the filing. It must refile properly, but its priority will be based on the new filing date. This reinforces why precise compliance with UC filing requirements is crucial. An administrative mistake can cost lender its priority interest. Question 4. During a major transformation where existing methods of securing loans are being restructured, a lender seeks to perfect a security interest in equipment owned by a debtor who operates in multiple states. The lender initially files a UC financing statement in the debtor's state of incorporation. However, the debtor later moves its principal place of business to another state without notifying the lender. The debtor also purchases equipment in third state using funds from the secured loan. The debtor then defaults on its obligations. Under Article 9 of the Uniform Commercial Code UC, how should the lender proceed to maintain perfection and priority in the collateral considering the relocation and newly acquired equipment? A. The lender's original UC filing remains effective indefinitely as long as the debtor does not change its name. B. The lender must file new UC in the state where the debtor has moved its principal place of business within specific time frame to maintain perfection. C. The lender automatically perfects its interest in the newly acquired equipment without additional filings. D. The lender's security interest in the relocated equipment is completely extinct upon the debtor's move. Answer. B. The lender must file a new UC in the state where the debtor has moved its principal place of business within a specific time frame to maintain perfection. Explanation. Under UC SS 9 316A 2, if debtor changes its location to another state, security interest perfected by filing remains perfected for 4 months from the date of the move. If the secured party does not file in the new state within this period, the secure interest becomes unperfected against subsequent purchasers and lien creditors. Option is incorrect because the original UC does not remain indefinitely effective when the debtor relocates. Option C is incorrect because after acquired property requires proper perfection procedures, and if the debtor is in new state, new filing is necessary. Option D is incorrect because while perfection lapses after 4 months, the security interest itself does not disappear. It just loses priority. Lender dealing with multi-state debtors must be vigilant about monitoring debtor relocations and ensuring timely continuation filings to maintain security interest priority. Question 5. In an environment where different components must interact in a secured lending arrangement, a bank lends money to a manufacturing company secured by its inventory and accounts receivable. The bank properly perfects its interest by filing a UC financing statement. However, a competing lender later provides additional financing to the same debtor and claims a purchase money security interest (PSI) in newly acquired inventory, which is later sold to customers. A dispute arises between the two lenders regarding priority. Which rule under UC Article 9 determines the priority of security interests in this case? A. The first lender has priority because it was the first to file a UC financing statement. B. The PAI lender has priority in inventory if it satisfies strict notice and filing requirements before the debtor takes possession. C. The first lender retains priority in all collateral, including newly acquired inventory, because of its after acquired property clause. D. The PAI lender loses priority because the inventory was sold to in the ordinary course of business. Answer. B. The PSI lender has priority in inventory if it satisfies strict notice and filing requirements before the debtor takes possession. Explanation. Under UC SS 9 324, PAI in inventory takes priority over conflicting security interest if the following conditions are met. The PAI lender perfects its interest at the time the debtor receives the inventory, or earlier. The PAI lender sends an authenticate notice to the first lender before the debtor receives the inventory. Option is incorrect because PAI rules override the general. The first to file or perfect rule when properly followed. Option C is incorrect because although after acquired clauses cover new inventory, they do not override properly perfected ESI. Option D is incorrect because PAI lenders priority applies before inventory is sold, and the question concerns disputes between creditors, not buyers in the ordinary course of business. Secured creditor dealing with inventory financing must be meticulous about proper notice and timing requirements to ensure PAI priority. Question 6. While investigating a complicated issue between different secured creditors, a court must determine the enforceability of a security agreement that describes collateral as all assets of the debtor. The debtor has defaulted, and multiple creditors are claiming rights to various types of collateral, including equipment, accounts receivable, and deposit accounts. Under Article 9, how should the court analyze the validity of the security interest? A general all assets description is valid in both the security agreement and the financing statement. B. A security agreement must reasonably identify the collateral and cannot use only more assets without further specificity. C. The financing statement must include serial numbers and detailed collateral descriptions. D. A secured party cannot claim an interest in deposit accounts unless the agreement explicitly lists them. Answer: B. A security agreement must reasonably identify the collateral and cannot use only all assets without further specificity. Explanation: under UCSS 9-108, security agreement must reasonably describe the collateral to create an enforceable security interest. The phrase "all assets" is insufficient in security agreement because it fails to provide clear description of what is covered. Instead, the agreement must specify types of collateral such as an inventory, equipment, or accounts receivable. The option is incorrect because while financing statement can use all assets, a security agreement must be more specific to be enforceable. Option C is incorrect because the UC does not require serial numbers in financing statements except for specific items like motor vehicles in some jurisdictions. Option D is incorrect because deposit accounts require control for perfection, but they can still be included in security agreement. This highlights the importance of precise collateral descriptions in security agreements to avoid disputes over enforceability. Question 7. During a major transformation where existing methods of securing loans are being restructured, a creditor discovers that its previously perfected security interest in the debtor's inventory may no longer be valid. The creditor originally perfected its interest by filing an UC1 financing statement in the appropriate jurisdiction. However, the debtor recently merged with another entity and changed its name. Under Article 9, how does the creditor maintain perfection of its security interest following the debtor's name change? A. The creditor must file new financing statement within 4 months of the name change to maintain perfection against new creditors. B. The creditor's original UC1 remains valid indefinitely despite the debtor's name change. C. The creditor must file an amendment to the original financing statement, but its security interest remains perfected without any time limit. D. The security interest is immediately rendered unperfected upon the debtor's change, requiring completely new filing. Answer: A. The creditor must file a new financing statement within 4 months of the name change to maintain perfection against new creditors. Explanation: under UCSS 9-507C, if debtor changes its name in such way that the original UC1 financing statement becomes seriously misleading, the security interest remains perfected only for 4 months. After that period, the financing statement becomes ineffective for new creditors unless an amendment or new filing is made. Option B is incorrect because name changes that make the original UC1 misleading trigger need for refiling. Option C is incorrect because while an amendment is required, the original perfection expires after 4 months unless updated. Option D is incorrect because the security interest does not become immediately unperfected. The creditor has grace period to correct the filing. This emphasizes the importance of monitoring debtor identity changes to avoid losing priority over collateral. Question 8. While investigating a complicated issue between different secured creditors, a bank notices that a debtor has pledged the same collateral to multiple lenders. The first lender filed a UC1 financing statement on January 1st, covering all equipment. The second lender, unaware of the first, made a loan secured by the same equipment and filed its UC1 on February 15th. The debtor defaults and both lenders claim priority. The superior claim under Article 9A, the first lender has priority because it filed first, regardless of the second lender's knowledge. B. The second lender has priority if it was unaware of the first lender's interest when making the loan. C. The lenders share equal priority since the debtor granted security interests to both. D. The lender with perfected purchase money security interest (PAI) would have priority over the first lender. Answer A. The first lender has priority because it filed first, regardless of the second lender's knowledge. Explanation. Under UCSS 9.322a1, priority among conflicting perfected security interests is determined by the first to file or perfect. This means that regardless of whether the second lender knew of the first lender's interest, the first filer wins in dispute unless special rule, such as PSI priority, applies. Option B is incorrect because knowledge of prior security interest does not affect filing-based priority. Option C is incorrect because that does not provide for equal priority in this situation. Option D is incorrect because while PAI in equipment could take priority, there is no indication that the second lender had PAI. This highlights the importance of conducting UC searches before lending to avoid taking subordinate security interest. Question 9. In an environment where different components must interact in a secured lending arrangement, a creditor takes a security interest in a debtor's accounts receivable. The debtor subsequently sells some of those receivables to factoring company in exchange for immediate cash flow. Later, the debtor defaults on its obligations to the secured creditor. Under UC Article 9, what determines priority between the original secured creditor and the factoring company? A. The factoring company has priority because it purchased the accounts outright. B. The secured creditor has priority if it perfected its interest before the accounts were sold. C. The factoring company has priority only if it filed a financing statement. D. The secured creditor automatically loses priority upon the debtor's default. Answer. B. The secured creditor has priority if it perfected its interest before the accounts were sold. Explanation. Under UCSS 9.318a, buyer of accounts receivable generally takes subject to previously perfected security interest. This means that if lender perfects its security interest in accounts receivable before the debtor sells them to factoring company, the lender retains priority even after the sale. Option is incorrect because selling receivables does not automatically eliminate prior security interest. Option C is incorrect because the factoring company's priority does not depend solely on filing financing statement. Option D is incorrect because default does not automatically strip the secured creditor of its rights. This scenario illustrates why lenders must monitor asset sales to protect their security interests. Question 10. In the financial landscape where various obligations interact and must be properly managed, a business debtor enters into a secured loan agreement with two creditors. The first creditor, lender A, filed a financing statement against the debtor's inventory on March 1st. The second creditor, lender B, an extended loan secured by the same inventory on April 15th, but was unaware of lender filing. Lender B argues that it was unaware of lender claim. It should have priority. Under UC Article 9, who has the superior claim? A. Lender has priority because it filed first, regardless of lender B's knowledge. B. Lender B has priority because it lacked knowledge of lender interest at the time of the loan. C. Both lenders have equal priority because the debtor granted security interests to both. D. Priority is determined by whichever lender enforces its claim first. Answer. A. Lender has priority because it filed first, regardless of lender B's knowledge. Explanation. Under UCSS 9.322a1, when multiple secured parties claim the same collateral, priority is determined by the first to file or perfect. This means that lender A, having filed first, holds priority over lender B, who, even if lender B was unaware of lender's security interest. Option B is incorrect because knowledge of prior security interest does not affect priority under the first to file rule. Option C is incorrect because the UC does not provide for equal priority in this scenario. Option D is incorrect because priority is not determined by which lender enforces its claim first. It is established at the time of filing or perfection. This underscores the importance of conducting UC searches before lending to ensure secured party does not end up in subordinate position. Question 11. As financial instruments evolve and impact secured transactions, a business enters into a loan agreement secured by its equipment. The lender perfects its interest by filing a financing statement. Later, the debtor relocates to another state without notifying the lender. What happens to the lender's perfected security interest under UC Article 9 after the debtor moves? A. The lender's interest remains perfected indefinitely. B. The lender must refile in the new state within 4 months to maintain perfection. C. The lender immediately loses perfection upon the debtor's move. D. The lender only needs to amend the original filing without filing in the new state. Answer. B. The lender must refile in the new state within 4 months to maintain perfection. Explanation. Under UCSS 316A. 2. If debtor moves to another state, previously perfected security interest remains perfected for 4 months. After that period, the security interest becomes unperfected unless the lender files in the new state. Option is incorrect because perfection does not last indefinitely when debtor moves to new jurisdiction. Option C is incorrect because there is 4-month grace period before the interest becomes unperfected. Option D is incorrect because an amendment to the original filing does not maintain perfection across state lines. New filing is required in the new state. This highlights the need for lenders to track debtor relocations to avoid losing secured status. Question 12. In a setting where collateral plays a critical role in financing agreements, a lender takes a security interest in a debtor's inventory. The lender perfects by filing a QUON. However, supplier later provides new inventory to the debtor under purchase money security interest (PSI) arrangement and also files a QUON financing statement under AC Article 9, who has priority over the inventory. A. The lender with the earlier filing date retains priority. B. The supplier has priority if it properly perfects its PI within 20 days of the debtor receiving the inventory. C. The security interests cancel each other out, leaving neither party with superior claim. D. Priority depends on the debtor's financial condition at the time of default. Answer. B. The supplier has priority if it properly perfects its PSI within 20 days of the debtor receiving the inventory. Explanation. Under UCSS 9. 324, B. PSI in inventory has super priority over previously perfected security interest if the PAI lender perfects its interest before or within 20 days of the debtor receiving possession of the inventory and sends proper notice to the existing secured part before the debtor takes possession. Option is incorrect because properly perfected PSI in inventory takes priority over an earlier filed general security interest. Option C is incorrect because that has clear priority structure. Option D is incorrect because priority is based on filing and notification, not the debtor's financial condition. This rule encourages suppliers to finance sales of goods by allowing them to reclaim priority under PAI structure. Question 13. As businesses expand their financial options to optimize cash flow, a debtor grants a security interest in its accounts receivable to lender. Later, the debtor sells the same receivables to a factoring company for immediate cash, who has priority under AC Article 9. A. Lender retains priority if it perfected its interest before the sale. B. The factoring company gains priority because it purchased the accounts outright. C. The priority is determined by the debtor's financial condition at the time of default. D. The factoring company's priority depends on whether it notified lender. Answer. A. Lender retains priority if it perfected its interest before the sale. Explanation. Under UCSS 9. 318A, buyer of accounts receivable takes them subject to previously perfected security interest. If lender perfected its interest before the sale, it maintains priority over the factoring company. Option B is incorrect because purchasing receivables does not automatically eliminate prior security interest. Option C is incorrect because priority is based on filing, not the debtor's financial condition. Option D is incorrect because notice does not affect priority in this case. Only filing order matters. This demonstrates why factoring companies must check for prior security interests before purchasing receivables. Question 14. In a financial landscape where various obligations interact and must be properly managed, a borrower obtains a revolving line of credit secured by equipment. The lender files a QUON financing statement to perfect its security interest. A year later, the borrower defaults and sells the equipment to a third party without the lender's consent, who has rights to the equipment under AC Article 9. A. The lender retains its security interest and can repossess the equipment. B. The buyer takes the equipment free of the lender's security interest. C. The lender loses its security interest unless it refiles within 30 days. D. The lender must seek compensation from the borrower rather than reclaim the equipment. Answer. A. The lender retains its security interest and can repossess the equipment. Explanation. Under UCSS 9. 315A, 1 perfected security interest continues in collateral even after the debtor sells or transfers it unless the lender authorized the sale free of its interest. Option B is incorrect because buyers generally take property subject to any perfected security interests unless they qualify as buyer in ordinary course of business by Option C is incorrect because refiling is not required in this situation. Option D is incorrect because the lender can directly repossess the equipment rather than just seeking damages from the borrower. This rule ensures that secured parties maintain their rights even if debtor improperly disposes of collateral. Question 15. As financial instruments evolve and impact secured transactions, a lender provides a loan secured by a borrower's farm equipment. The lender perfects its interest by filing a financing statement. However, the borrower later relocates to another state. What happens to the lender's perfected interest under Article 9? A. The lender's interest remains perfected indefinitely. B. The lender must reperfect in the new state within 1 year to maintain priority. C. The lender must file lawsuit to enforce its claim before the borrower's move. D. The lender automatically loses its security interest upon the borrower's relocation. Answer. B. The lender must reperfect in the new state within 1 year to maintain priority. Explanation. Under UCSS 9, 3168-2, when debtor moves to different state, perfected security interest remains valid for 1 year. However, if the lender fails to file new UC1 in the debtor's new state within this time frame, it loses perfection. Option is incorrect because perfection is not indefinite across state lines. Option C is incorrect because lawsuit is not required to maintain secured interest. Filing in the new state is the key step. Option D is incorrect because the lender has grace period to maintain its security interest. This rule protects lenders while also ensuring debtors cannot escape security interest simply by moving. Question 16. In a setting where collateral plays a critical role in financing agreements, a business debtor pledges inventory as collateral for multiple loans. Lender files a UC1 financing statement on January 1st, while lender B files a purchase money security interest PSI on January 15th, properly notifying lender before the debtor receives the inventory, who has priority over the inventory. A. Lender has priority because it filed first. B. Lender B has priority because it properly perfected its PSI. C. Both lenders share equal priority. D. Priority depends on the debtor's financial condition. Answer. B. Lender B has priority because it properly perfected its PSI. Explanation. Under UCSS 9, 324, B. PAI in inventory has priority over an earlier filed security interest if the PAI lender perfects before or within 20 days of the debtor receiving possession, and the PAI lender sends notice to the first secured lender before the debtor takes possession. Option is incorrect because properly perfected ESI overrides prior general security interest. Option C is incorrect because priority is determined by EAI rules not shared equally. Option D is incorrect because priority is based on filing and notification, not the debtor's finances. This rule promotes financing for inventory purchases by granting PAI lenders super priority status. Question 17. As businesses expand their financial options to optimize cash flow, a debtor sells accounts receivable to a factoring company. However, a prior lender already holds a perfected security interest in those receivables, who has priority. A. The prior lender if it perfected its security interest before the factoring sale. B. The factoring company since it purchased the receivables outright. C. Priority is determined by the debtor's financial condition. D. The factoring company's priority depends on whether it notified the lender. Answer. A. The prior lender if it perfected its security interest before the factoring sale. Explanation. Under UCSS 9, 318A, buyer of accounts receivable takes them subject to any pre-existing perfected security interest. If lender perfected before the sale, it retains priority. Option B is incorrect because purchasing receivables does not eliminate prior security interests. Option C is incorrect because priority is based on filing order, not debtor finances. Option D is incorrect because notification is not required for perfected lender to maintain priority. Factoring companies must check for pre-existing security interests before purchasing receivables. Question 18. In commercial lending, conflicts often arise between secured parties and buyers of collateral. A borrower grants a security interest in equipment to lender A, who perfects it by filing a financing statement. The borrower then sells the equipment to a buyer in ordinary course of business, but does the buyer take the equipment free of lender security interest? A. Yes, because buyer takes free of prior security interest in inventory. B. No, because lender perfected its security interest before the sale. C. Only if the buyer was unaware of the lender's security interest. D. Only if the buyer paid fair market value for the equipment. Answer. A. Yes, because the buyer takes free of A prior security interest in inventory. Explanation. Under UCSS 9-320, a buyer in ordinary course of business takes the inventory free of perfected security interest, even if the buyer is aware of it. However, this rule applies only to inventory sales, not equipment sales. Option B is incorrect because buyers take free of security interests in inventory even if the lender perfected first. Option C is incorrect because knowledge does not affect the BIOC exception. Option D is incorrect because paying fair market value is not condition for BIOC protection. This rule promotes confidence in commercial transactions by allowing ordinary buyers to take goods free of lender claims. Question 19. In a competitive financial environment where multiple lenders seek priority, a business debtor grants a security interest in its equipment to lender A, who files a Aquan financing statement on March 1st. On April 1st, the debtor grants the security interest in the same equipment to lender B, who properly perfects its interest. However, lender B later discovers that lender never had an authenticated security agreement with the debtor, who has priority under Article 9. A, lender A, because it filed first. B, lender B, because lender never had an enforceable security interest. C, the debtor, because neither lender had a valid claim. D, priority must be determined by a court. Answer. B, lender B, because lender never had an enforceable security interest. Explanation. Under UCSS 9-203b, for security interest to be enforceable, the lender must have value given e.g. loan or financing rights in the collateral and an authenticated security agreement or possession control of the collateral. Since lender never had an authenticated security agreement, it never perfected valid security, even though it filed first. Lender B's interest prevails because it properly perfected its security interest. Option is incorrect because filing a loan does not establish priority. There must also be an enforceable security interest. Option C is incorrect because lender B does have valid claim. Option D is incorrect because this is straightforward rule, not matter requiring judicial determination. This scenario emphasizes the importance of proper documentation in secured transactions. Question 20. As secured lending structures become increasingly complex, a borrower grants a lender security interest in accounts receivable. Later, the borrower sells some of those receivables to a factoring company. The lender properly filed an Aquan financing statement before the sale, while the factoring company did not. Who has priority in the accounts receivable? A, the lender, because it perfected its security interest before the sale. B, the factoring company, because it purchased the receivables. C, the borrower, because receivables cannot be used as collateral once sold. D, priority is determined by the debtor's financial condition. Answer. A, the lender, because it perfected its security interest before the sale. Explanation. Under UCSS 9-318, a buyer of accounts receivable takes them subject to any prior perfected security interest. The lender perfected its interest first, meaning the factoring company bought encumbered receivables. Option B is incorrect because purchasing receivables does not override prior security interest. Option C is incorrect because borrowers can sell receivables even if they are collateral. Option D is incorrect because priority is based on perfection, not the borrower's financial status. This rule protects lenders who finance businesses based on accounts receivable. Question 21. In an economic landscape where businesses seek to optimize asset use, a borrower uses its inventory as collateral for a line of credit. The lender perfects its security interest by filing an Aquan financing statement. Later, the borrower sells inventory to a buyer in ordinary course of business but who has rights to the inventory. A, the lender retains its security interest. B, the buyer takes the inventory free of the lender's security interest. C, the lender can seize the inventory from the buyer. D, the buyer must pay off the lender's claim before taking ownership. Answer. B, the buyer takes the inventory free of the lender's security interest. Explanation. Under UCSS 9-320a, buyer in ordinary course of business takes goods free of prior perfected security interest. This means the lender cannot reclaim the inventory once it has been sold in the normal course of business. Option is incorrect because secured interests in inventory do not survive sales to buyers. Option C is incorrect because the lender cannot seize inventory already sold to buyer. Option D is incorrect because the buyer does not owe the lender any payments. This rule encourages unrestricted commerce by protecting buyers who purchase goods in good faith. Question 22. As businesses leverage assets for financing, a borrower grants a lender a security interest in farm equipment. Later, the borrower moves to another state without notifying the lender. What happens to the lender's security interest? A. It remains perfected indefinitely. B. It remains perfected for 1 year, after which the lender must reperfect in the new state. C. The lender must file lawsuit to enforce its interest. D. The security interest is automatically void upon relocation. Answer: B. It remains perfected for 1 year, after which the lender must reperfect in the new state. Explanation: under UCSS 9. 31682, security interest remains perfected for 1 year if the debtor moves to another state. If the lender does not file new UC1 in the debtor's new state within this time frame, the security interest becomes unperfected. Option is incorrect because perfection is not indefinite. Option C is incorrect because lawsuit is not necessary. Filing in the new state is the key step. Option D is incorrect because there is 1 year grace period. This rule ensures stability in secured transactions while allowing debtors to move. Question 23. In a dynamic lending environment where security interests may overlap, a debtor grants a lender security interest in equipment. However, the debtor then sells the equipment without the lender's consent, who has priority under Article 9. A. The lender retains its security interest. B. The buyer takes the equipment free of the lender's interest. C. The lender loses priority unless it refiles within 30 days. D. The lender must seek damages from the borrower instead of reclaiming the equipment. Answer: A. The lender retains its security interest. Explanation: under UCSS 9. 315A. 1. Perfected security interest continues in collateral even after it is sold unless the lender authorized the sale free of its interest. Option B is incorrect because buyers generally take property subject to any perfected security interests. Option C is incorrect because refiling is not required in this case. Option D is incorrect because the lender can reclaim the equipment rather than just seeking damages. This rule protects secured parties from unauthorized sales by debtors. Question 24. In a financial transaction where priority is critical, a lender loans money to a business and perfects its security interest in the business's equipment by filing a financing statement. Later, the business purchases additional equipment using financing from another lender who also perfects its security interest in the new equipment. Who has priority over the newly purchased equipment? A. The first lender because it perfected its interest first. B. The second lender because it financed the purchase of the new equipment. C. The business retains priority as it purchased the equipment. D. Priority is determined based on the financial status of the business. Answer: B. The second lender because it financed the purchase of the new equipment. Explanation: under UCSS 9. 324A, purchase money security interest (PSI) in equipment has priority over prior perfected security interest if the PAI lender perfects within 20 days of the debtor receiving the equipment. Option is incorrect because general security interest in all equipment does not override properly perfected ESI. Option C is incorrect because the business does not have priority if lenders have perfected interests. Option D is incorrect because priority depends on filing NPL rules, not the debtor's financial status. This rule encourages businesses to obtain financing for new purchases while protecting secured lenders. Question 25. As financial institutions navigate secured transactions, a debtor grants a lender security interest in its inventory. The lender files a financing statement, but the debtor also grants another lender a security interest in accounts receivable generated from the sale of that inventory. Who has priority over the accounts receivable? A. The inventory lender because it had a prior perfected interest. B. The accounts receivable lender if it perfected its security interest properly. C. The debtor because accounts receivable are separate assets. D. Priority is determined by court order. Answer: B. The accounts receivable lender if it perfected its security interest properly. Explanation: under UCSS 9. 322A, the first to file or perfect has priority unless specific priority rule applies. In this case, the inventory lender has security interest only in inventory, not automatically in receivables. The accounts receivable lender has direct security interest in proceeds which can be separately perfected. Option is incorrect because the inventory lender does not automatically get rights in receivables unless stated in the agreement. Option C is incorrect because secured parties, not debtors, get priority if interests are perfected. Option D is incorrect because priority rules apply directly. Courts do not need to decide unless there is dispute. This highlights how lenders must specify collateral types clearly. Question 26. In a lending environment where secured interests overlap, A company grants a lender a security interest in all business assets to secure a loan. Later, the company leases specialized equipment, with the lease agreement stating that the leasing company retains ownership. Does the lender's security interest cover the leased equipment? A. Yes, because all business assets includes leased property. B. No, because the leasing company retains ownership. C. Only if the lender files a claim within 30 days. D. Only if the lease is for more than 5 years. Answer B. No, because the leasing company retains ownership. Explanation. Under UCSS 9-10981, security interest only applies to the debtor's rights in the collateral. Since the company does not own the leased equipment, the lender cannot claim an interest in it. Option is incorrect because the term all business assets applies only to owned property. Option C is incorrect because timing does not change ownership rights. Option D is incorrect because lease duration does not affect ownership. This emphasizes why lenders must verify borrowers' ownership of assets before claiming security interests. Question 27. In a secured lending environment where debtors seek flexibility, a borrower grants a security interest in a warehouse full of inventory. Later, the borrower moves half of the inventory to another location. Does the lender's security interest extend to the moved inventory? A. Yes, if the lender's financing statement covered all inventory. Would be no, because the inventory is in different location. C. Only if the borrower updates its loan agreement. D. Only if the lender files new AQUAN for the new location. Answer A. Yes, if the lender's financing statement covered all inventory. Explanation. Under UCSS 9-315A1, perfected security interest continues in collateral even if it is moved as long as it remains within the same jurisdiction. Option B is incorrect because location changes do not extinguish security interests. Option C is incorrect because the loan agreement does not need an update. The security interest applies automatically. Option D is incorrect because no new filing is needed unless the debtor moves to new state. This rule ensures that lenders maintain rights in collateral even when inventory moves within the state. Question 28. In financial transactions where collateral transfers are common, a borrower grants a security interest in a fleet of delivery trucks. Later, the borrower sells one truck to a third party without the lender's consent. Who has rights to the truck? A. The lender, because the security interest remains. B. The buyer, because it purchased the truck. C. The borrower, because they facilitated the sale. D. The lender, only if it files an additional claim. Answer A. The lender, because the security interest remains. Explanation. Under UCSS 9-315A1, perfected security interest continues in collateral even if sold unless the lender authorizes the release of the collateral. Option B is incorrect because buyer does not take the truck free of the security interest unless they qualify as buyer. Option C is incorrect because borrowers cannot unilaterally eliminate security interests. Option D is incorrect because the lender does not need to file new claim. The security interest remains. This rule protects lenders against unauthorized sales of collateral. Question 29. As businesses seek alternative financing, the debtor pledges inventory as collateral for a loan. The debtor then transfers inventory to a subsidiary, arguing that the security interest no longer applies. Does the lender still have rights in the inventory? A. Yes, because the security interest follows the inventory. B. No, because ownership has changed. C. Only if the lender amends its AQUAN filing. D. Only if the lender files a lawsuit. Answer A. Yes, because the security interest follows the inventory. Explanation. Under UCSS 9-315A1, security interest remains in transferred collateral unless the lender agrees to release it. Option B is incorrect because transferring collateral does not eliminate the lender's rights. Option C is incorrect because new AQUAN is not required for the interest to remain valid. Option D is incorrect because priority is determined by filing rules, not court action. This prevents debtors from evading secured obligations by moving collateral. Question 30. In a secured lending scenario where timing is critical, a business grants a lender a security interest in its inventory. The lender perfects its interest by filing a AQUAN financing statement. However, before the lender files, another creditor seizes the inventory through a court judgment lien. Who has priority over the inventory? A. The lender, because it has a perfected security interest. B. The judgment creditor, because it acted first. C. The lender, only if it can prove the business intended to prioritize its loan. D. A priority is split equally between both parties. Answer: B. The judgment creditor, because it acted first. Explanation: under UC SS 9 317A2, judgment lien creditor has priority over security interest unless the security interest was perfected before the lien attached. Option is incorrect because the lender perfected its interest after the judgment lien was in place. Option C is incorrect because intent does not override filing requirements. Option D is incorrect because priority is determined by filing and attachment, not an equal split. This highlights the importance of timely filing to protect secured interests from third-party claims.